Hi, everybody. Thanks for tuning in. We appreciate it. We're with movers and shakers today. Specifically, we're with Craig Capilla, Esquire of Chicago, Illinois, attorney extraordinaire, defense attorney extraordinaire, because he defends us, real estate appraisers. Craig, how are you this morning?
I am excellent. How are you doing?
Great, thank you. Now, the last time we spoke, you were driving home to Chicago from, what was it, Madison, Wisconsin, in a blizzard?
So I was driving home from Flint, Michigan
Flint,
in a
Michigan, that's right.
blizzard, having just spoken earlier that day to the Great Lakes chapter of the Appraisal Institute. And then I would have thought the drive home in the blizzard was maybe the most difficult thing I was going to have to deal with for the foreseeable future. And in reality, a week or two later, things radically changed far beyond my expectations.
And you were at home with, as I recall, three small children?
So, well, two small children and a dog that really is no more advanced than the 3-year-old.
Okay,
So
so things were kind of interesting around your house.
it has been a slog for the last period of time. We are slowly here as we're recording this. We're slowly advancing in our phases of restoration or whatever you want to call it here in Chicago. But again, with some tremendous limitations. Theoretically, yesterday the parks here have reopened. I will tell you, we've not been to one at this point. There is now the beginnings of dining allowed in restaurants. They had allowed for outdoor dining a little bit earlier, which, as you know, is only a 6-week window in Chicago anyway. So it has been a process.
So you're home, your wife's home, the kids are home, but yet you still somehow manage to practice law. Is that correct?
It's somewhat restricted. I actually have to say we jokingly around March at the firm started referring to this as all of us working from our new 6 satellite offices in our firm expansion. We all ended up in a work from home setting, and fortunately we have managed to get through that aspect of the practice fairly well. Kind of by hook or crook, we've realized that our technology backstop really, it held up. It allowed us to do what we needed to do. We had to become a little bit more rigid in our scheduling so that we would have regularly set conference calls, just making sure everyone in contact. But again, knock on wood, fortunately, the firm has really held strong through this. We've been able to continue doing what we're doing. And now we're at a point where the courts are starting to open up again. So we're actually able to start moving our active litigation forward again. There was a pretty hard stop on that for a while. And all of that is starting to press forward again as well in a format similar to this. I have now been to court several times exactly as we are right now via Zoom, or because hearings are supposed to be open to the public. I have had court calls, hearings before a judge that are actually live broadcast over YouTube, which is something that I never thought I would see. And kind of necessity being the mother of invention, the way we go about practice radically shifted in the course of about 6-8 weeks.
Wow, that's a revolutionary change, isn't it?
It is, because in other areas, not only were there no cameras allowed, I was still writing on carbon paper in triplicate. So if you can imagine the timeline acceleration to get from that to live stream is radical.
Now, you mentioned your office. If you would be so kind, would you give us the way we can get in touch with you if we need to do so?
Absolutely. So there's a couple of ways to go about that. My phone number at the office, this is just the main switchboard and it goes through to everyone, so it'll get distributed, is area code 847-716-2380. And that number will go to the main switchboard. It'll get distributed to who it needs to go to. So you can call that number, ask for me directly. It'll get to me. And if I'm not at my desk for whatever reason, cool little technological point, we now have voicemail that will be transmitted through to me wherever I am. It's a beautiful thing. This is one of those nice little, actually, it's a horrible thing in some circumstances, but it's a beautiful thing. Also, our website is www.charlesfranklinlaw.com. That's all one word smashed together. That's the website. You can find me on there. My email address to get in contact with me that way is my first initial and last name. So it's CCAPILLA at charlesfranklinlaw.com. But if you forget the front end of that, just go to the website itself. You can click through, get my email address, and send me a message. And please, anyone out there, if you've ever got a question or a concern, don't hesitate to reach out. That's exactly what we're there for. If we can help, great. If we can't, we can hopefully point you in the right direction with someone who can, and we're happy to do that as well. So thanks for taking the time to get that information out there. Anyone who needs to use it, don't hesitate. Please reach out. That's what we do.
Now, you're licensed to practice law in Illinois and Wisconsin, right?
That's correct. So for the states, as far as that goes, Illinois and Wisconsin, and then several of the federal districts as well. We don't see too much federal litigation normally with appraisals, so we've got some other stuff that we handle too. And we're also active with temporary practice permits, basically, because lawyers like Latin. For us, it's pro hoc vice. And we're active in a number of other states, admitted temporarily on certain matters as well. So while I'm licensed in Illinois and Wisconsin, we do practice a bit of all over because we kind of have a niche in this stuff. So again, it's even if we're not specifically in the state that somebody has a question or whatever, either we might be able to help or we probably know someone that can.
So if someone down here in the swamps of Florida needed some legal advice relative to a state charge, even though you're not licensed directly to practice in Florida, they could still get in touch with you and you could still help them, correct?
Yeah, we could get them pointed in the right direction to do that. For their specific case, we may be able to appear pro hoc vice as well in Florida. Truth be told, though, Florida is actually one of the states that we've tended not to tread into greatly because there are some tremendous resources to help people if they have board complaints down in the state of Florida. So what I'm going to suggest is, while they may need a lawyer of some sort, oftentimes people need some consultation work, maybe a little bit of review work, maybe a little guidance on how this works. So at that point, I'm probably going to refer them to some website like perhaps the Appraiser's Advocate or someone else like that that might be boots on the ground situated to do that sort of thing.
I love the shameless plug, Craig. Thank you very thoughtfully. So, speaking of shameless plugs, take a look at what you're seeing right now. Go down to that bottom right-hand corner and mash that subscribe button and hit that bell so you can stay up with stuff like this. Now, Craig, you and I have chatted numerous times. We've chatted at various conferences over the years. We've chatted over the phone. Um, One of the major areas that you in which you engage on literally a day-to-day basis is defending appraisers against lawsuits, against state charges, etc. Now, we had spoken a little bit earlier about the concept of due diligence. Now, USPAP doesn't bother to define due diligence. For that matter, neither does Fannie Mae or Freddie Mac. There are some legal definitions of due diligence, but given the fact that USPAP doesn't have that definition yet in Standard Rule 1-1 A, B, and C, specifically B and C mentions due diligence or due care. Let's start off this conversation. Let's start off this opportunity to help other appraisers with talking about at least a small definition of due diligence. What, especially from a legal standpoint, when a court is looking at due diligence, when attorneys are looking at due diligence, what is it they're looking to see? What is it they're looking not to see? And what is it they look for to find a lack of due diligence?
Well, fortunately, while the foundation has not necessarily seen fit to develop a definition of due diligence yet, or at least include it in the text that everyone is to follow, the courts have taken the opportunity to decide that matter for us. And so there is actually a string of case sites that has kind of ported over various jurisdictions, but a general definition of due diligence exists. And it's essentially, let's see if I can still do this. I may have to dig into notes, but I think I can probably do a good bit of this from rote memory, which is because we like to speak in a stilted manner as attorneys. So it always starts oddly. It's just such a manner of prudence, activity as is to be expected from or exercised by a reasonable person under the particular circumstances. And I want to say I probably got that about 85% of the way there. But unpacking that so that we're now just talking like normal people again, what the standard of due diligence is understood to be in just about any jurisdiction I'm aware of. I don't know of any particular nuance that's unique to an area, but due diligence is really an expectation of professionalism and competence. It's the individual who is supposed to meet a standard of due diligence to perform diligently is held to a reasonableness standard of, did you take appropriate caution and care? Did you do the level depth of analysis or research that a reasonable person would do in the circumstances in which you provided that work? So USPAP, as you said, does not define due diligence, but it sounds to me that a common understanding of what due diligence might be is a thread that works its way through USPAP in development standards, touches on competency a little bit as well, and it ultimately boils down to, is it a commonly known acceptable method or practice? Is it one that your otherwise peers would also engage in? And did you do it? Was it appropriate for this assignment? That really now becomes the backbone of understanding, at least in my mind, due diligence as applied to an appraisal assignment.
Now, earlier you mentioned the word effort. Let's talk about the concept of effort. When an appraiser just phones it in, the appraiser just filling in the blanks and cutting and pasting boilerplate. And yeah, the appraiser comes up with a number and it's probably somewhere in the middle of the neighborhood range. Is that appraiser exercising due diligence, or is that appraiser putting him or herself at potential risk for not having engaged in the proper effort?
So my position on that would be there has been some undue risk assumed by the appraiser, but that doesn't mean that the appraiser is going to get caught out on it. Understand that strict adherence to the USPAP standards or state license law or other professional association standards or guidelines is a requirement of the job, but a failure to adhere to those things is no guarantee that trouble will arise. They're related items, but they track separately. And fortunately, while discussing due diligence and kind of the appropriate processes here to fully and adequately develop an assignment is something of a timeless subject. I don't care. You can go back to sorts of the beginnings of the framework around real property valuation. And I dare say that somebody could watch this exchange between you and I 25 years from now. I mean, I feel for them dearly if they are, but somebody could do that. The concepts we're discussing here should be evergreen. I don't see an issue here where there's going to be some radical change. This commentary should stay fresh the entire time and relevant. But the time in which we're speaking about this is rather important because, as you know, we're recording this right now on the tail end of the first round of coronavirus COVID-19 related impacts to the market and economic distress for a lot of folks. Unemployment numbers are stratospheric at the moment as we're recording this. I will tell you then, using that as a present circumstance when considering due diligence, the requirement, the steps, the processes to perform a competent and credible appraisal assignment are no different today than they were 6 months ago. But the risk today of being turned into a state license board or being served with a lawsuit is much higher today than it was 6 months ago. Well, does that mean that there is a failure today to perform due diligence by appraisers that didn't happen 6 months ago? No, absolutely not. Unfortunately, I think there's a lot of appraisers out there today that wake up this morning with an assignment exactly the same way they woke up with an assignment 6 months ago. Does that mean they're doing it wrong today, but they were doing it right 6 months ago? Certainly not. But is somebody likely to take issue with that more so today than 6 months ago? My experience tells me yes. I just did a presentation tangential to this, but really dealing with coronavirus related concerns and liability issues. Just did a presentation with Peter Christensen out in California. He and I did this together. And one of the areas that we kept coming back to, a point we were really harping on, was forget the magic bullet idea as a timely concern. There is no magic pandemic language that is suddenly going to make the report bulletproof and you're all okay. Nobody turned off USPAP in the pandemic. The requirements of the job today as we sit here are exactly the same as the requirements of the job 6 months ago, a year ago. That process hasn't changed, but claims arise, license complaints and lawsuits arise when the recipient is under distress and is now much less willing to let slide errors and omissions that they may have just let go before because, I got what I needed. It's okay. I might be a little bit unhappy about this, but it all worked out. No big deal. Well, that the magnifying glass has been reapplied to this. Everything is a big deal. So as a result, a new, or I should say a renewed focus for the individual appraiser on really crossing the T's and dotting the I's, the research, the analysis, and the tightened reporting is absolutely critical right now. It's no different than it was before, but it's never been more important than it is right now.
Craig, in following up with this, a lot of appraisers are saying that despite the current state of affairs, they're just absolutely as busy as they can possibly be. They're cranking out reports as fast as they possibly can, and consequently, they're making a lot of money. Now, let's take a look at this solely from a standpoint of cranking out a lot of reports. Do you think that the fact that appraisers are, quote, cranking out a lot of reports is done at the expense of the quality of the report? Or do you feel that that cranking can take place without an accompanying decrease in the quality of the analytics behind the value opinion?
So I'm going to go out on a limb here, and I realize I may be in the minority a bit on my answer here. I actually think appraisers do have an ability to increase their volume of production, perhaps quite significantly, and still meet applicable standards. I don't think there necessarily has to be a quality drop off to meet a significant increase in production. Now, if you had asked me that same question 5 years ago, I would probably be answering that question a little bit differently. And that said, I think for the individual appraiser, it's critical that every appraiser for themselves understand, though, that those two items are in tension. There has to be always a balance between speed and accuracy. And really there's a pyramid that goes to all of that too. There's speed, accuracy, and cost. And those things all come together. Now, I'm going to remove cost from the discussion because unfortunately we know for many appraisers, specifically those practicing in residential mortgage lending, cost, or rather the price of their services, is not something necessarily that the individual appraiser can control. So we're going to just remove that as part of the balance. And we're going to say that that may just be a constraint that you have to live with. Tangent to that point, if you can diversify your practice to not hold all of your eggs in that basket, I think that's a fantastic idea because it can help address the concerns of cost or pricing, and frankly might just improve quality of life and stress, dealing with stress and whatnot as well. But be that as it may, if we're talking specifically residential mortgage lending assignments for those appraisers, there has been, and for quite a while, there has been, I think, a strong tension, a strong pressure to really increase the speed with which an appraiser can produce a report. And I would have been much more concerned 5 years ago, 10 years ago, the lead up to 2008, the 2004, 2005, 2006 run of things, even into 7 when we hit the market peak. And those people who were talking about, I'm just doing more and more reports every day. Okay, we know that didn't work, and we now know why. I think the technology available to support appraisers today is drastically improved over what was available 10, 15 years ago. And so I do think the appraisers have the ability to perform more assignments, take on more work today than they did 10 or 15 years ago, and still produce an accurate, a credible product at the end. But that's not unlimited either. You can't go all the way to just cranking out work and expect that you're going to meet that minimum necessary level of accuracy and credibility. And understand, we're only talking about a minimum. Each individual appraiser here has to decide what is an acceptable work product of mine. What can I live with and sleep with at night restfully with my eyes closed and not have panic attacks and nightmares about, oh my goodness, did I let that one out of the barn too soon? You all know that you have people out there that consider themselves to be your peers that have a level that's about here, and that would give you an ulcer. And there are many of you that also have a level that's up here, right off the camera. But the reasonableness standard is here. If you're the sort of person that says, fine, that may be the standard here, but I can't look myself in the mirror because I know I can produce this, well, then maybe ratcheting up the volume of your work product really isn't for you. And that's okay, because you can't ever let an assignment out the door that you're not comfortable with and you're not willing to put your name to. But for the folks that are in this range, go, hey, I am comfortable in my practice making good enough. I think technology has just been a boon for those folks. What I think we'll also come to find out over the next several years is a lot of people in the range of not hitting that standard at all to begin with have looked at the available technologies and gone, great. Do you know how much more of this I can do right now? And the more that you do below the bar, the higher the likelihood that you're going to be called to the bar at some point. So there's a balance to all of this. Absolutely, I think appraisers can do more assignments now without sacrificing their level of quality. But for the individual appraiser, they need to determine for themselves what their individual level of quality is before they can adequately determine for themselves if they can take on that much more work. Because I believe, when I was talking to Peter believes our phones are going to start ringing. And a lot of that has to do with stress and external factors, not the specific appraisers themselves. But the appraisers that were doing subpar work 6 months ago, a year ago, are probably still doing subpar work today. It's just that now somebody's really going to care about it. So is it helpful that I can keep doing subpar work, but I can do twice as much subpar work? I'd suggest maybe you're just doubling the chances that someone's going to take issue with your subpar work.
Speaking of being invited to a bar to which most people would really not like to be invited, let's talk about the fact that you started out your legal career as a prosecutor for a state board. Now, put your prosecutor hat back on, and with the concept of due diligence, what is it that a prosecutor in a state appraisal board looks for, or actually, what is it that the prosecutor looks for, knowing it's not there, to determine that indeed the appraiser did not engage in proper due diligence?
So I've always looked at the enforcement process of an appraisal a little bit differently, I think, because of the training that I got at the state end. And let me build a foundation for that a little bit. First of all, the foundation and some strong leadership within the profession actually did a fantastic job. Arrow was involved in putting together some great training at the state levels for their board investigators, enforcement attorneys, even some of the board members at a certain point. So, I had the great advantage of actually getting instruction from folks like Larry Disney and Dennis Badger and folks like that, which is just invaluable training for somebody who's not an appraiser by trade. I came to this from a transactional practice, so I knew my way a bit around a real estate closing file, and I certainly had looked at appraisals, but I was not then, nor am I now, and I think even now, truly an expert in this, but I had some wonderful hand-holding along the way. I also was very fortunate to come in as a prosecutor at the state of Illinois with tremendous unrest. I started as a prosecutor the week before Bear Stearns collapsed. Okay, so you can imagine what that sort of a timeline does to your learning curve when you've actually taken the information fire hose and just had it opened up on you. That's it at that point. It's just drinking from a fire hose for the first year and a half, basically, that I was working for the state of Illinois, but had some absolutely fantastic help within the agency. Brian Weaver as the appraisal coordinator, who's actually still, as we record this, some 13 years, I think, later, Brian is still the appraisal coordinator at Illinois. We had board members at the time, Tim McCarthy and Maureen Sweeney, Bob Gorman, some fantastic board members during the time that I was there that all really, it's molded me into how I look at this stuff. And so from a very early point in enforcing appraisal regulatory concerns, I actually approached the process sort of from an inverted posture. People start looking at USPAP, and we incorporated and adopted USPAP into state law, and so that was what was really enforceable. There was some stuff outside of USPAP, but it was either of a very technical nature or it was so egregious as to be ethical concerns that you could always attach an ethics rule violation to it, but it was specifically enumerated in law. The reason is ethics rule is actually a very hard one. Competency rule is a very hard one. Due diligence, or I think as you and I were kind of alluding to, standard one, is a very hard one. I always started my analysis of an appraisal and its flaws from a standard two perspective. It's far easier for me to digest and explain if somebody has fallen short and failed to meet a standard two requirement reporting. It's either there or it's not. It's adequately stated or summarized, or it's not. But I will tell you that the basis for every one of those concerns in a standard two perspective, the basis for each one of those was born of standard one and competency. The development, the analyses were either performed or they weren't. The due diligence was handled appropriately or it wasn't. And if it wasn't, that was typically what gave rise to a standard two deficiency in the report. Simply put, the appraiser didn't have the ability to adequately state or summarize or even fill in the box period on a form report because of a failure to develop the appraisal assignment in that standard, because of a failure to complete the due diligence process. But actually proving due diligence process failures are very hard, especially at a state board level, when you're frequently talking about a burden of proof that is, it's a heightened standard. It's typically what's called clear and convincing, which again, now we go back to definitions. The definition of the clear and convincing burden of proof is that which is both clear and convincing. Okay, that is a useless definition, but it's the one that we're stuck with. What we know is that it is much, much nearer to the criminal standard of beyond a reasonable doubt than it is to the civil litigation standard, most typically for most legal causes of action, which is a preponderance of the evidence. And that happens to be just more likely than not likely. So that's the background and training. And that's kind of how I was taught to look at an appraisal report when trying to dissect it, is starting from a reporting perspective and implying my way back down to the development concerns. Now, fortunately, if you've got your hands on a work file, and the work file presumably contains all of that which the appraiser considered, relied on, utilized in the development of the report, you can get yourself closer again to getting to standard one type concerns. But especially if you're just looking at a report itself in a vacuum, standard two is really all you have to sink your teeth into. But overwhelmingly, almost every time, the errors or omissions that you're seeing within the report from a standard two point of view really originate earlier in the process, development, due diligence, and it's that sort of a lacking, which, coming out of state licensing concerns for a moment and going right into the courtroom, if you're now dealing with something where you're talking about a lawsuit because of negligence, okay, someone at some level is upset with the appraiser. You didn't do a good job. You were negligent. It's professional negligence. Appraisers are information providers. Whether or not the appraiser was producing reliable, or we'll call it credible, assignment results is the very subject matter of a trial at that point. And so errors in standard two reporting can be implied back to standard one development concerns. Now we've had the benefit of full discovery. There's been depositions taken. All documents So anything in the work file, all communications surrounding the assignment, all of those items have all come out and been exchanged between parties. Now, a competent plaintiff's counsel who understands the mechanics of how this works doesn't have to hit that high standard that a board prosecutor has to hit. They only have to explain to the jury, who doesn't have the slightest idea what any of you actually do for a living, they only have to explain to that jury, is it more likely than not likely that you didn't do what a reasonable person would have done here? Suddenly, that due diligence requirement is a lot more in play in that circumstance. It's a lot easier to get to that. And it took me a while to learn that once I came out of the state, because we always had to play ball at that heightened standard of scrutiny. Suddenly in a civil suit, you're now looking at these things going, holy smokes, it is not hard to wind a tale here that this appraiser just, hey, sure, they might have had a bad day, but they fell short and they were responsible. And so thank goodness that E&O pot of gold is at the end of the rainbow, because that's what it's there for. Well, there are a lot of folks out there in the practice space, I'm talking about law practice now, that's exactly what they see when they think real estate appraiser is. They actually see the pot of gold at the end of the rainbow. That pot of gold is, unfortunately for most of the folks doing residential mortgage lending, that pot of gold, you actually attach it typically as the last page of your assignment. It's your insurance deck page. And that's now what has become the focal point for all of these things.
So when the state brings a charge against an appraiser, what you're saying is it has a relatively high standard to meet in order to demonstrate that the appraiser did indeed violate state law and or USPAP. Is that correct?
So that is the technical legal standard that for most types of professional licensure, whether you are a real estate appraiser or a doctor or you name it, the vast majority of jurisdictions, I'm not going to say every single one, because I'm not entirely certain of that, and some people have thrown a curveball, or some states, I should say, have thrown a curveball from time to time. But overwhelmingly, the standard for professional licensure disciplines is a heightened standard. It's not all the way to the criminal standard, but it's awfully gosh darn close. Now, that's the legal standard. Now, I think you and I have been around the block enough times to realize that in practice, depending upon the government administrators, the temperament of the various members sitting on the board at any particular time, that is still a bit of a moving target. It can certainly feel, when you're the appraiser under investigation, it can certainly feel like that standard is a wee bit lower. And I think we've probably both seen cases or case results that have come out of a particular state or a particular circumstance and gone, ooh, goodness, did they really find that to be a violation? So by no stretch of the imagination here am I meaning to give a false sense of security to any of the viewers of this, thinking, it's way harder than you think to get in trouble. Don't take that away from this. But strictly legally speaking, yes, it is a heightened standard. I think if I could give a takeaway point on that, it's that in a civil suit, it's actually far easier to get in trouble than you think it is. Rather than it's far harder to get in trouble at the state level, I turned that one on its head. It's actually a lot easier at the civil suit level to get in trouble than you might think, because they don't have to hit the standard that the state does to still extract money out of your insurance policy, or God forbid that you don't have appropriate coverage, your bank account.
Wow, Craig, that certainly puts a really sunshiny spin on the morning, doesn't it?
I'm a cheerful kind of guy.
Craig, again, one more time, if you'd be so kind as to tell us how we can get in touch with you should that need arise.
Certainly. Again, the easiest ways to contact me are right through the office. My phone number at the office, area code 847-716-2380. And my email address is my first initial and last name. So it's CCAPILLA at charlesfranklinlaw.com. And please, folks, feel free to use either one of those. Always happy to field questions. And again, if we can help you, great. If we can point you in the right direction, great as well. And we're always happy to help.
Craig, thank you. And ladies and gentlemen who are listening to this, thank you. Again, let me recommend Craig. He knows whereof he speaks. Now, if I can ever be of help to you, please get in touch with me at tim@theappraisersadvocate.com. And again, smash that subscribe button in the bottom right-hand part of the screen and click on the bell so you keep getting YouTube videos just like this one, as informative and as timely as they are. Craig, again, thank you. My best to your family. And I hope that the next time we get together, you can bring one of those guitars and give us a little blues riff for a little while.
We'll see what we can do. Tim, thank you so much for having me on. It's great to catch up like this again. Obviously, we were supposed to have seen each other several months ago. That fell by the wayside. Hopefully, though, next time we do get to see each other, it actually can be in person again. And I really appreciate you having me here. Don't ever hesitate to reach out. And I really appreciate the opportunity.
Craig, yes, again, it's an honor and a pleasure to work with you. Thank you so much. And we're clear.